the question of where we're supposed to go fishing.
Yes.
I think my colleagues are taking advantage of my being a lady. Just a minute, just a minute. My lords,
ladies don't fish.
My lords, the first and second respondents served us with their response at 1 a.m. yesterday. We waited for them. One of the things they say they served us with is this hard disk. It was not served on us. It was not given to us. As it is, by the time they showed up at 1 a.m., they were way out of time. We were courteous to them, we waited for them, we received their documents. The hard disk was not one of those documents. Later on in the day, at about 12:30-something, 12:38 p.m., somebody from the IBC brought the hard disk to us and said it had fallen out accidentally. By the time we had already filed our application. So if it is to look for this document, or we being accused of not having read what they had given us, it is not true because we did not have it. That was just to set the record straight. My lord, we have been accused of not reading.
Before you go there, now that you have that key, hard disk, do you want us to give you time to peruse through it and see whether the information you seek is there, so that we don't even have to rule over this on this application?
My lord, I think that might not be necessary, because what we want is live access, not pre-downloaded data whose origin is not verifiable. And I say this with the caution that the last time in the August petition, this was one of the issues that came up, because the second respondent, first and second respondent, did not want to give live access to their documents or to their servers. They wanted to give pre-downloaded forms or pre-downloaded data that could not be verified, could not be ascertained. So it is not helpful that they claim they have given us this data that has already been pre-downloaded. It also goes to deal with the issue that there are several different types of forms out there. That, of course, raises then the question as to why do we have different returns. My clients, who were observers in the field, obtained forms. Those forms are different from what the first and second respondent uploaded onto their portal. The question is, why are they different? The purpose of scrutiny is then to verify the information or the data, because these forms were availed by the first and the second respondents. If they do not correspond with what is in the KIMS data, which should have captured the details, then this court must determine. Again, we talk about forgery fraud, which was an issue that arose out of the last election. The verifiability, the authenticity of the documents and the returns that are filed by the second respondent. It is important.
Have you exhibited the forms you have yourself?
Yes, my lord, and I was...
Which are different from the ones IBC has...
we have.
Yes.
I was coming to that, and we have been accused of not pleading these matters. In the affidavit of Billy Atudo, because scrutiny arises out of our pleadings and our affidavits, the affidavit of Billy Atudo addresses this question thoroughly. It is in volume 5 all the way to, and the annexures from volume 5 to volume 14, where he addresses even the Muranga forms, the Garissa forms. We have produced all 100 of them. We have produced the ones that have been availed by IBC, from the ones we got from the IBC portal, and the ones that our observers produced. In the application, we simply made it easier by putting them together side by side so that it is easier for reference, but they are all part of the affidavit, and the annexures already filed in court in support of the petition. I have said from volume 5 all the way to volume 14. They are referred to also for reference to where in the affidavits they're found. It is paragraph 35 to the end, and also from paragraphs 3, we talk about the forms and the discrepancies in the forms. My Lord, on the question, on the issue of the complementary method of identifying voters, the 1.6 million voters, the law is very clear. The Elections General Amendment Regulations 2017 at Regulation 31, my Lord, and I can do no better than to read what the law already provides and compare it with what the IBC gave, the instructions they gave to their presiding officers. Regulation 69 was amended at subregulation E that in case the electronic voter identification device fails to identify a voter, the presiding officer shall invite the agents and candidates in the station to witness that the voter cannot be identified using the device. The presiding officer shall complete verification form 32A in the presence of the agents and candidates and identify the voter using the printer register. My Lord, Form 32A is one of the returns that ought to have been filed and produced before this court. None has been availed, not one. And it is through Form 32A that we can verify these voters that are alleged could not be identified through the electronic voter identification device. Again, just to show that that is what is expected, in our application we had referred earlier to the guide that was given by the second respondent to its presiding officers. At page 130, what should be done where a voter cannot be identified biometrically but can be identified alphanumerically, it states what is to be done. In the event the voter's details are not retrieved biometrically in the first instance, clerk should make a maximum of 3 attempts. It goes on to say what should be done. In case the details are not retrieved in the third attempt, Clerk 1 will proceed to undertake an alphanumeric search using the voter's ID, passport number, or name, or scanning of the barcode. In case of supervisor validation, the PO completes the KIMS supervisor validation form, see the form below, and invites the party candidates' agents to sign the forms as witnesses. These KIMS supervisor validation forms are part of the returns that are supposed to be produced by the second respondent to verify those who were not identified biometrically. They have not produced any of those forms. They go hand in hand with Form 32A. My Lords, then part of the documents that are supposed to be submitted at the end, together by the presiding officers to the returning officers at page 142, the second respondent makes it very clear what their presiding officers should do. And they say, together, packaging and delivery of election materials, together with other materials, the presiding officer should deliver to the returning officer the ballot box, the original result declaration form 34A, any used or spoiled results from form 34A in a tamper-proof envelope, the register of voters, polling station diary, KIMS kit and all its accessories, failed Forms 32A, failed Forms 32, statement of rejected ballots, Form 41, and KIMS supervisor validation forms. These are returns that are supposed to be delivered by the presiding officer to the returning officers. They are the same forms that are supposed to be used by the returning officers to verify those who are not identified biometrically and to carry out the verification process at the National Tallying Center. So when we talk about verification, how do we verify what the second respondent is talking about when they have not availed the materials or the returns that they should have produced?
Wind up.
May I have a minute to wind up, my Lord? My Lord, finally, the respondents talk about time and that we do not have time to do this or to do the scrutiny that is called for. Sampling is a widely accepted method of studying large numbers of subjects. This is what the court did in August. This is what the court did in 2013, and which is why we're asking for a sampling. It is not impossible to do, and the court should not be scared away by this data overload that the second respondents are trying to project before the court. I think I will leave it at that unless the court, sorry, my senior Mr. Ndubi will do the last remarks if that is okay with.
Yes.